sorry not to be with you in person today, and especially sorry I'm missing the other speakers. I hope I'm not repeating what they've already said. But this was a weekend when I simply could not risk a canceled flight. I've had a very happy marriage for 54 years. I very much want to keep it that way. And if I'm not in New Orleans tomorrow to board a cruise ship, my bride is going to be very, very unhappy. And as the saying goes in Texas, if mama ain't happy, ain't nobody happy. I think the original idea was that I would somehow integrate these three cases, but they don't really have much to do with each other. And given the result in Drummond, they don't even have the usual unity these days that the free exercise claim always wins. But it's a reasonable bet that someone with that claim will win the next time around. The free exercise win streak is about to end more definitively, I think. On Monday, the court heard argument in Landor v. Louisiana, and it went pretty badly for the plaintiff. The issue is whether prisoners can sue prison employees for damages under the Religious Land Use and Institutionalized Persons Act, and it sure sounded like the conservatives are going to say no. The popular image is that conservatives on the court support religious liberty and liberals do not, but that isn't true. Catholic Charities was unanimous, although Justice Jackson offered a theory by which she thought the state might still win on remand. Unanimity is not unusual in free exercise cases. Church of the Lukumi on animal sacrifice was unanimous. Cutter v. Wilkinson on Establishment Clause challenges to religious exemptions was unanimous. Gonzalez v. Ocentro on hallucinogenic tea used in worship services was unanimous. Hosanna Tabor on the ministerial exception was unanimous. Holt v. Hobbs on prison beards was unanimous. Tanzen v. Tanver on suing federal employees under the Religious Freedom Restoration Act was unanimous. Graf v. DeJoy on accommodation under Title VII, religious accommodation, was unanimous. So all the justices support the free exercise of religion, but most of them have other issues that they care about more. The liberals care more about gay rights, abortion, contraception than about religious liberty. Some of the conservatives care more about governmental immunities and about hustling capital defendants to their death than they do about religious liberty. So we get free exercise, votes against free exercise, when for some of the justices, one of these conflicting interests counts for more than the free exercise clause. Beyond that, I think I have to talk about these three cases one at a time. So start with Mahmoud v. Montgomery County. Montgomery County decided to add LGBT issues to the reading curriculum in grades kindergarten through 5. There were 7 books initially. The 2 most controversial were dropped in response to the threat of litigation. Of the remaining 5, 2 end in it with a same-sex wedding. 2 are focused on trans children. A trans boy says he doesn't want to look like his mother. When he grows up, she has to help him become a boy. One describes a puppy love romance between 2 little girls. Part of the rationale was that children from gay and trans families should be represented in the curriculum. But the guide for teachers also said the goal was to disrupt student thinking about sex and gender. Student thinking, of course, much influenced by what they were taught at home. So the goal here is to undermine what they're being taught at home. Initially, parents were allowed to opt their kids out, but too many parents opted out in the school board's view, and so the ability to opt out was repealed. There were 4 sets of plaintiffs from 4 different faith traditions. They sued alleging free exercise violations. Preliminary injunction was denied in the district court, denied in the Fourth Circuit, granted in the Supreme Court 6-3 on the usual ideological lines. I don't agree with much of what the current Supreme Court majority does, but I think they got this one right. My view is, as Mark mentioned, civil liberties must protect everybody, including both sides in the culture wars. I invested a lot of time and energy over the years urging legislators and the Supreme Court to protect same-sex marriage and at the same time to protect religious dissenters. Sexual orientation, gender identity, religious belief, religious practice. These are all fundamental to human identity. They are hugely important to individuals, and the government's reasons for interfering are generally pretty weak by comparison. So they all deserve constitutional protection. The parents claimed that these books interfere with their right to direct the religious upbringing of their children. They withdrew their children from public school and at substantial expense sent them to private schools instead. They did not ask that the books be dropped from the curriculum. They did not ask that they be removed from library shelves or from shelves in the classroom. They asked that their own children be excused when these books were read aloud or discussed in class. The defendant said, the lower court said, and the dissenter said that this case was only about exposure. No one was required to change their opinion about sexual orientation or gender identity. No one was required to do anything that violated his religion. You were only required to listen. That argument has been around for a very long time. It's one of the arguments the 19th century Protestants made about reading the King James Bible in public schools. Catholic children were beaten and expelled for refusing to read what they called the Protestant Bible. There were riots and mob violence over the issue. School officials said that Catholic children didn't have to believe it, they only had to read it. And it's part of what schools say in modern Establishment Clause cases. You don't have to believe it, you only have to recite it or sit or stand quietly and respectfully. And it's part of what schools and lower courts have said over the last 40 years in other cases seeking exemption from parts of the curriculum. You don't have to believe it, you only have to read it and learn it. The Supreme Court majority in McMood took the case as though it were only about exposure. And they said that exposure violates the Free Exercise Clause if it undermines religious teachings at home and if it is not justified by a compelling government interest. They might also have said, and I think they should have said, that Montgomery County did require parents to violate their religious commitments. These parents believed that they could not knowingly allow their children to be exposed to this material at this age. That's why they pulled their kids out of public school. It's a familiar religious teaching in many faiths that one should avoid exposure to or protect one's children from books that are inconsistent with faith. Lead us not into temptation, Jesus prayed. There are many reasons to disagree with such teachings. Maybe it's better to read a wide range of opinions and ideas, but avoiding ideas that undermine faith is a familiar religious teaching, obviously protected by the First Amendment. The other defense of the claim in Mahmoud was that chaos will ensue. All kinds of religious zealots will demand opt-outs from all parts of the curriculum, and the schools won't be able to cope. We will see. If it happens, schools will be able to prove a compelling interest in narrowing the opt-out right to manageable bounds. But for now, the claim is completely speculative, and speculation does not make out a compelling government interest. Schools individualize curriculum in all sorts of ways. They are required to individualize for disabled students and for students just learning English. Most states have legislated a right to opt out from sex education. Many states have more broadly applicable opt-out rights. Montgomery County had a generally applicable opt-out right. Parents could opt their kids out of pretty much anything until it was largely repealed in response to this controversy. I'll just tell you about the one example I know best. Texas enacted a generally applicable right to opt out of curriculum in 1995. You cannot opt out of a test. You cannot opt out of an entire semester, but there are no other limits or exceptions. There are no reported cases. There is no attorney general opinion. There are 3 administrative decisions in the Office of the Commissioner of Education in 30 years. The General Counsel to the Texas Association of School Boards says that the right to opt out has been a nothing burger. Montgomery County says they got a large number of requests to opt out of these books. I don't know how many, just that the board said it was too many. It's not clear whether they thought the number was unmanageable or whether they thought that the opt-outs were undermining their goal of disrupting student attitudes about sex and gender. But larger numbers and greater resistance are what you get when you attack core beliefs of our largest religious minorities. Once a majority, but now minorities, especially in blue and purple states. We know they're a minority because they keep losing on these issues and politically and have to resort to the courts for protection. So what can schools teach? They can and they should teach tolerance. In grades K through 5, that mostly just means be nice. But as LGBT issues arise more naturally, as kids get older, teachers can be more explicit. You may not like what the trans kids are doing, but they have a right to do that. They're equal citizens under our law. You have to treat them fairly and equally. You do not have to approve of what they're doing or believe in what they're doing, but you have to respect their right to live their own lives in their own way, and they have to respect your right to live your life in your own way. Catholic charity has already been discussed by able panelists, so I assume I don't have to walk you through the facts. I think the court got this one right too, but it involves some careful line drawing. I wrote and filed briefs in pretty much every Supreme Court free exercise case for more than 30 years. From Jimmy Swaggart and Mergens in 1990 to Groff v. DeJoy in 2023. Age, declining energy levels, and other commitments left me signing on to briefs written by others in Mahmood and Catholic Charities. But the only time in those 33 years that I filed in support of the government was Zubik v. Burwell. I filed for the Baptist Joint Committee for Religious Liberty. And Zubik presented an issue similar to, but importantly different from, the issue in Catholic Charities, and the comparison is illuminating. Zubik was the second case on the contraception mandate. The Obama administration, the Affordable Care Act said that employer insurance plans had to provide free coverage for contraception. The Obama administration had exempted religious organizations, and many of them accepted that, but some of them said not good enough, you have to exempt our secular insurers as well. So one argument was whether refusing to exempt the insurers was a burden on the free exercise of the policyholders. But second, the administration had voluntarily exempted the secular insurers of churches and their integrated auxiliaries. Integrated auxiliary is a term from the tax code. It describes the religious organizations that are most tightly connected to the church itself or to the synagogue, mosque, temple, etc. Plaintiffs argue that exempting insurers for churches and their integrated auxiliaries showed that there was no compelling interest in refusing to exempt insurers for everybody else. And they argued that the distinction was irrational because some religious organizations just outside the boundaries of integrated auxiliary were not much different from other organizations just inside that boundary. We responded that this argument was a mortal threat to all legislative religious exemptions. So a bit of background. There are two kinds of legislative religious exemptions. There are broadly applicable standards like substantial burden, compelling interest, and least restrictive means in the Religious Freedom Restoration Act. And there are specific rules that try to resolve specific religious liberty issues that government can anticipate, like the exemptions from providing contraception and that were at issue in Zubik. Specific exemptions may be broad or they may be narrow, but they cannot cover everybody on the planet. They must have a boundary. And often there is no good place to draw that boundary. There is the church itself. There are affiliates. Some religious nonprofits are subject to the direct control of a church. Some are subject to indirect control. Some are entirely independent. Some have a strong religious identity, but no affiliation with a church. Some have a weak religious identity. At the outer edge of religious nonprofits are organizations that retain a nominal religious identity, but have lost any real religious commitment. Some organizations at the end of the religious nonprofit continuum are not really much different from secular nonprofits. And beyond these are organizations that have wholly lost any religious identity. Some of our great secular universities were founded by churches to train clergy. Beyond the nonprofits are for-profit organizations, some of which retain deep religious commitments, as Hobby Lobby illustrates. And beyond those are for-profit organizations that are wholly secular. And both inside and outside all these organizations, there are individuals with strong or weak or no religious commitments. Wherever a line is drawn in this expanding circle of possibilities, there'll be organizations and individuals just outside that line that aren't much different from others just inside the line. Those denied exemption sometimes look a lot like those granted exemption. And if every narrow religious exemption irrationally discriminates against those just outside the boundary, and if every narrow exemption shows that there's no compelling interest in a broader exemption or refusing a broader exemption, then every narrow exemption automatically gets expanded in the first lawsuit, and every narrow exemption becomes a universal religious exemption. And if that happens, most legislatures will not enact any exemptions at all. So exemptions have to have boundaries, and legislators and administrative agencies deserve some deference in how they craft and draw those boundaries, but the boundaries cannot discriminate. The exemption in Zubik for churches and their integrated auxiliaries exempted the core of communal religious exercise, the organizations closest to the place of worship. That boundary is not perfect, but it is not discriminatory. Every organized religion has such a core. This narrow exemption left some employees without access to free contraception, but expanding the exemption to all religious nonprofits would have left vastly more employees without access to free contraception, doing vastly greater damage to the government's interest. So returning to Catholic charities, the problem in Catholic charities was not that the state exempted some religious organizations and not others, as the plaintiffs argued. The problem was, as the court explained, that the exemption was discriminatory. Discriminated between faiths. Distinguishing discriminatory from non-discriminatory boundaries is not always easy in this context, but Wisconsin's boundary pretty clearly discriminated. Some religions offer charities to all in need, and as a matter of principle, do not take advantage of that need to try to convert them. Other religions do try to take advantage of that need. Before the soup comes the sermon or the prayer service. The first group was taxed in Wisconsin. The second group was exempt. That distinguished different religious organizations on the basis of one of their faith commitments, and that was unconstitutional, 9-0. So what about Justice Jackson? She said Wisconsin could tax all charitable organizations, religious and secular alike, without regard to whether the religious ones proselytized or didn't proselytize. If you were principally charitable, you were not exempt. And that may well be right. That would leave a pretty narrow exemption, but it would not be an exemption that discriminates on the basis of religious teachings. It would raise a different question. There are a bewildering variety of secular exemptions in the Wisconsin unemployment tax. Some of them are narrow. Some of them can be understood as not undermining the state's interest. I've not undertaken to inventory them, let alone to master them. But they raise the question of whether this tax is neutral and generally applicable, and whether that matters. In Jimmy Swaggart Ministries in 1990, the court held that taxing the religious functions of the church is not a cognizable burden on religious exercise, unless the tax is so onerous that it effectively chokes off an adherent's religious practices. If there's no substantial burden, does it matter whether the law is neutral and generally applicable? Well, some of the courts of appeals have said it does matter that any discrimination against religion requires compelling justification, whether or not it imposes any other substantial burden. In effect, discrimination is the burden. And the Supreme Court has held that discrimination in the administration of subsidies requires compelling justification. That's Trinity Lutheran, Espinoza v. Montana, and Carson v. Macon. The court would never hold that a mere failure to subsidize is a substantial burden on religious exercise. But discrimination in the administration of subsidies requires compelling justification. So it may be that a tax with a secular exemption must have religious exemptions, just as a regulation with secular exceptions must have religious exemptions. And that might render Justice Jackson's Plan B for Wisconsin unconstitutional unless the state gets rid of a lot of its secular exceptions. But that's an issue down the road. I'm not going to try to forecast today how that might turn out. I have a bit less to say about Drummond, partly because there was no opinion, partly because it seems mostly a replay of Carson v. Macon. With respect to government-sponsored prayers and religious displays, I am a hardliner on the Establishment Clause. But with respect to money, I take a different view. The founding generation decided the government should not fund the religious functions of churches, and that decision is held. None of the modern cases are about that. The modern issue is whether government can fund secular services, especially education, delivered by religious organizations and often alongside some religious instruction as well. And the founders never faced that issue. As Marx said, I believe the religion clauses leave religious choice and commitment as much as possible to each of us individually and to the organizations we form. So that requires government to be neutral with respect to religion. And by neutral, I mean neutral incentives. Government should neither encourage nor discourage religious belief or religious practice. It's basically the first two prongs of the lemon test, neither advance nor inhibit religion, interpreted literally instead of in some of the strange ways the court administered it. And with respect to money, the only course that doesn't distort incentives is to fund everybody or nobody. Nobody is encouraged to change their religious behavior in either direction if doing so cannot increase their funding. So I think the recent cases on non-discriminatory funding are rightly decided. Funding secular schools, but not religious schools, encourages religious schools to secularize and penalizes those who cannot or will not do so. Now, back when I first heard about charter schools in the 1980s, I thought it was a fiction to characterize them as public schools. Government didn't operate them, and the whole point was that diverse private organizations would do things that government could not do or would not do. When reporters first began calling me about Drummond, I said the case turns on whether charter schools are public schools with private management or private schools with public funding. If they're private schools with public funding, as I then thought, then Carson v. Macon controls. Carson v. Macon says if government undertakes to fund, in part, private schools, it cannot discriminate against religious schools. It must fund religious and secular schools alike. On reflection, I don't think that how we characterize charter schools makes much difference. Suppose they are public schools with private management. Why should government be allowed to discriminate in awarding this very valuable franchise? The opportunity to manage a charter school comes complete with funding and the opportunity to teach your worldview to a group of children. Discrimination in the awarding of that opportunity distorts religious incentives just as much as discrimination in funding of what we all agree are private schools, as in Carson. But then opponents say if they're public schools, they're subject to the Establishment Clause, and they can't teach religion or conduct religious exercises. And on this issue, maybe it does matter whether they are viewed as public schools or not. But more fundamentally, letting a religious group run a charter school only on condition that it not teach religion defeats the whole purpose of prohibiting discrimination and of letting the religious group run the charter school in the first place. And it raises the next great question in the wake of Carson v. Macon. If government includes religious schools in a non-discriminatory funding program, what strings can it put on that aid? Do religious schools forfeit their right to religious exemptions if they accept government funding? Does government get a free hand to regulate whatever it funds? Or is regulation that interacts with the group's religious exercise an unconstitutional condition? That issue is being litigated on remand in Carson. Maine enacted legislation providing that if you take government money, you lose your religious exemptions from the gay rights laws. Same issue in Drummond. Does the group running the school lose its right to teach religion if it accepts government funding? I think the court will say no in these two examples, and that it should say no. Some conditions government can impose. Obviously, it can require that the organization accepting funding actually perform the service that the government is trying to get funded. But the restrictions on religious exercise in the course of providing that service should require a compelling justification. So 3 cases, 3 very different sets of issues. That's my first take on them, and I'm happy to hear some questions or comments.
Great, Doug, thank you so much. I've got a few questions collected from the audience here and happy to collect more as people have them. Doug, the first question we have from the audience is just sort of stepping back from the nitty-gritty of these 3 cases. Do you have thoughts about just sort of current religion clause doctrine writ large? Are there certain tests or cases they're particularly confused? I know earlier on one of the earlier panels, the kind of historical hallmarks of establishment was one of the things that was discussed. The relationship between Smith and the funding cases like Carson was another thing that was discussed. But just, can you give us some thoughts on kind of your overall view on where we are in the doctrine? What are the kind of big unresolved questions or sort of problems that you see kind of looking at it from 10,000-foot view?
Well, on the free exercise side, the court is working its way out from under Smith. There's some votes to just overrule Smith, which would simplify life. They may never have to overrule it because there doesn't seem to be any law that they can't find to be not neutral or not generally applicable. I think at times they have, and I've been an opponent of Smith. I've been a strong supporter of free exercise. But I think at times they actually were too aggressive. In some of the COVID cases, they were comparing religious services to things that weren't comparable at all. In a worship service, people sitting shoulder to shoulder for an hour and a half is not at all the same risk of contagion as a retail store where people come and go and are not crowded together. If we overrule Smith, that analogy wouldn't matter, but there may well have been, at the peak of COVID, there may well have been a compelling interest in some restrictions on live worship services. On the establishment clause, one other thing about whether to overrule Smith. If every case has to begin with whether the law is neutral and generally applicable, but if the court can always find a way through that and conclude that the law is not generally applicable, then it doesn't change results, but it complicates every litigation. And we'd be a lot better off if they would just overrule Smith. On the establishment clause side, hasn't quite been repealed, but we're certainly headed that direction. As I said, I think what they're doing on funding actually makes sense. It gets government out of the way if they prohibit discrimination in funding. Of course, they are not saying, and I can't imagine they ever would say, the government is required to fund the private sector. But if it does fund the private sector, then it cannot discriminate on the basis of religion. On the government prayer and religious display side, there's hardly anything left. We had explicitly Christian prayers upheld in the town of Greece. We've had a 40-foot cross in the middle of the biggest intersection in town upheld. The Coach Kennedy case a couple of years ago was written on the theory that that was his private speech and not in an official capacity. So it's not clear how far that goes and whether it will be interpreted based on what the court said the facts were, on what the facts really were. The conservative religious community is certainly trying to run with it based on what the facts really were. So it's the first breach in the school cases, right? The restrictions on government-sponsored prayer in schools have held for 60 years. I have assumed they would continue to hold. I think they'll continue to hold, but I'm no longer confident. I don't know how far 5 of these 6 people are willing to go. And the football field was Coach Kennedy's classroom. If he can pray there with students gathered around him, Why can't a history teacher do it in her classroom? Don't think we're going to go there, but I think that issue is now up for grabs. The Ten Commandments cases, new legislation in Texas and Louisiana requiring the Ten Commandments to be posted in every school. That's currently pending on rehearing in Bank in the Fifth Circuit, clearly headed to a cert petition, and clearly a bet that the Supreme Court will overrule its earlier decision on posting the Ten Commandments in classrooms. So the attack on secular public schools is moving forward, and it's unfortunate.
Thanks so much, Doug. Our next question here, sort of related to something that we talked about earlier, and you mentioned the kind of battle going on in Catholic Charities right now on remand. The question is, if restrictions on religion in charter schools go away substantially, will the result be that the states just end charter schools, reducing choice even further? And I think I could expand out the question a little. Where you have these kind of religious liberty doctrines premised on equality, is there a risk in the charter school context or other school contexts that a state could just say, you know what, forget it. Just nobody is going to get the benefit now once we equalize it.
Yeah, that is a risk, and I assume it'll happen in some blue states. I don't think it'll happen in a large number of states, but it will probably happen in some places. And I think advocates need to be aware of that risk. And on this issue and on other issues, like the risk I talked about of saying narrow exemptions discriminate have to become broad exemptions. But I think when it's an issue of just explicit discrimination on the basis of religion, we probably have to take that risk. The court can't very well write an opinion that says we're upholding religious discrimination in this case because we're afraid the legislature will do something even worse. And it's always an issue in equal protection cases. Do you level up or level down? Generally, we level up, but occasionally the court levels down or allows the legislature to level down. And that risk is just inherent in equality litigation.
Thanks. Our next question is about kind of have a couple questions along the same lines here about exemptions and the current court. And I think one way to phrase kind of these questions, together is the current court's very solicitous to a lot of free exercise claims and exemption claims. And you might wonder, or this person asked, is there a risk that the court is going to broaden these religious exemptions for some religions like Christianity over others, or sort of, how should we think about the concern that, the court is really solicitous as to some religious claimants and less solicitous as to others?
Of course, that's a risk. And the high profile cases lately have been conservative Christians for the most part. And the lead plaintiff in Mahmoud was a Muslim family, but there were Christian plaintiffs as well. It's a risk, and there's some evidence of it in the lower courts. Obviously, we have a much smaller sample size in the Supreme Court. I don't see that it's been happening. The Christian community in Hialeah thought that Church of Lakumi should be banned because it was a sacrilege. It was about as far removed from Christianity as could be imagined, and the court protected it 9-0. Similarly, with the group using hallucinogenic tea in Gonzales Rio Centro. So there are non-Christian cases, there are Jewish cases. I don't think that risk is large, but it's certainly there. It's easier to protect a religious practice that seems familiar and non-threatening, or that you understand. Somewhat harder to protect a practice that just seems weird. So yeah, there's a risk, but I don't think it's been a great risk so far.
Thanks. Next question is sort of a methodological question, I think. The current court is very oriented toward history. There are several justices on the current Supreme Court that are self-professed originalists. And we've seen that can cash out in different ways. You might think there's an argument going on among the justices right now as to what's the relationship between history and kind of how we adjudicate cases under modern doctrine. The court's Second Amendment cases put forward sort of one path that you might take and how to do that. And the free exercise cases maybe put forward some other path. But I wonder if you have any thoughts about that, given just stipulating that a lot of the justices are historically minded, they're going to have to face questions about how do we create modern doctrinal rules. And I wonder if you have thoughts about, what's the connection between history and doctrine? What should it be? Or what are some blind alleys that would be better if the court didn't go down?
Well, history is always relevant. One question to ask about any clause of the Constitution is, what problem were they trying to solve with this? An interpretation that doesn't address that problem is probably a wrong interpretation. But most of the Bill of Rights is worded in quite general terms, so it's not limited to the particular problem they're trying to solve, but the language has to be interpreted to address that problem. There are many problems with originalism, but the one that has always loomed largest to me, not so widely represented in the literature. Originalism says we are prohibited from learning from experience. And we have 230 years of experience with the Constitution. We know a whole lot more about how it works than the founders ever did, or that they could ever foresee. And of course, we have to interpret it in light of what has worked and what has not worked, and how the problems that were addressed in their time have evolved into our time. So history is relevant, but it cannot be definitive. I am, in important ways, a textualist. I think the text is where you start. I don't think it's exclusive. I think we'll look to other modes of interpretation as well, but not the text as originally understood. The text as it is actually written. We are part of the linguistic community that they were writing for, and what the text means to us is important as well. Now, more recently, the court has said, well, we interpret some of these clauses in light of history and tradition. That's not really originalism. That's something different. And it is utterly incoherent. They have no way of deciding which history and which traditions count, which traditions were compliant with the clause you're trying to interpret, and which tradition violated it. The history and tradition of religion in our public schools is we beat and expelled Catholic children for refusing to read the Protestant Bible. And it wasn't just occasionally, and it wasn't just for a year or two. It went on for decades. Well, they're not going to say that's what the Establishment Clause means, but how are they going to avoid saying that's what the Establishment Clause means? The whole history and tradition thing is ridiculous, but they seem more and more committed to it, at least rhetorically. How much it is actually influencing their decisions is harder to say. Right? If they don't much like a claim of right, and if it wasn't recognized in the 19th century, then it's pretty easy to say no history and tradition of this. But if they do like a claim of right, they either won't talk about history and tradition, or they'll find a way to make it fit. So these are not good developments at the court.
Yeah, our next question is a little more specific, related to funding. And the question is, the theory of Trinity Lutheran and these follow-on cases is equal treatment. That's the theory. But if religious entities are able to get an exemption from funding conditions, and I think you touched on that earlier, like non-discrimination in admissions, for instance, doesn't the equal treatment rationale, sort of go away? Doesn't it put significant pressure on it? Are we giving them now special treatment?
Yeah, that is a fundamental question that I've tried to address over the years. So start from my starting premise, which you don't have to share, but this is my view of the matter. The government should, as much as possible, avoid changing the incentives to um, religious belief or religious behavior and practice. Um, Money is always an incentive. Money has cash value to everybody. And if you say, um, you don't have all that much religion in the curriculum, so it's not a big deal. Why don't you just drop all of it and then you can have this money? That's a pretty powerful incentive. Religious exemptions are not neutral in terms of neutral categories, but most of the time, and I'll talk about exceptions, but most of the time, religious exemptions are neutral in terms of incentives. Um, if we say, uh, if you uh, don't send your Amish child to high school, you'll be fined, and if you persist, you'll eventually go to jail. That is a powerful disincentive to keep your kid out of high school. Um, but it's not much of an incentive for anyone outside the Amish community. Nobody in Wisconsin suddenly pulled their kids out of school after Wisconsin versus Yoder, unless they were already Amish and already committed to the view that they should educate their children home on the farm. And similarly with most other exemptions. Most religious practices have meaning only to the people who share the religious belief that gives them meaning. And people outside of that faith commitment are not incentivized to begin a religious practice just because it's no longer illegal. Um, so for the most part, exemptions uh, have much less effect on incentives than the threat of government penalties, and similarly in the funding context. Um, Now, I said there are exceptions. Sometimes religious practice aligns with secular self-interest. And then exemptions do have incentive effects. And then it is very hard to figure out how to be neutral. So uh, the draft exemption, when I was young, um, there were powerful secular reasons not to want to go to Vietnam. There were also powerful reasons to exempt conscientious objectors. The court never found a constitutional right to draft exemption and accepted a legislative solution with restrictions that Congress thought were manageable and put on it. Similarly with tax exemption. A lot of legislative tax exemptions, no constitutional tax exemption. And if saying you were consciously opposed to paying taxes got you out of paying taxes, well, the whole Republican Party would convert next week, and a lot of Democrats wouldn't be very far behind. In the drug cases, uh, as far as I'm aware, no one has ever won an exemption from the marijuana laws because there's a huge recreational market for marijuana. And claiming the religious exemption would enable you to use marijuana recreationally as a practical matter. Be very hard to separate out the seriously religious from the others. But huasca, this tea from the Brazilian jungle, and peyote, the drug that was involved in Smith, do not have significant recreational markets, principally because they make you throw up before they make you high. There are other drugs that are more attractive recreationally. And so the court did not find a compelling interest in refusing exemptions with respect to those drugs, but all the lower courts have found compelling interest with respect to marijuana. So you have to make sure that that you're not that the exemption isn't aligned with some secular practice that is widespread and that will encourage people to either adopt the religion that is exempted or falsely claim to have adopted the religion that is exempted. But that's a problem only in a minority of cases. So the short summarizing the short answer to the question is Um, religious exemptions mostly create neutral incentives, and equal funding pretty much always creates neutral incentives.
Great, thank you so much. Well, Doug, we have just one more minute, so I'll give you the final word. If there's anything you'd like to say or any predictions you would like to make, no pressure on you. But where you think the court is heading next, what things do you feel hopeful about or dread?
Well, I think this issue of putting strings on the funding, regulations taking away exemptions in the funding is headed their way sometime in the next few years, maybe sooner rather than later. There's still issues to be worked out on the boundary between gay rights and religious liberty. Masterpiece Cake Shop is a notoriously ambiguous opinion. I think they're headed towards pretty general protection for religious dissenters, but there are probably more cases to come in that line. The attempt to put religion back in public schools is headed their way, starting with the Ten Commandments cases. But if they take one of those cases and overrule their earlier decision, then there will be more aggressive things, more aggressive practices to follow. I'm generally optimistic about what they're doing on free exercise and deeply pessimistic about what they're doing on government-sponsored prayers and religious displays. And that's kind of where I am at this point in my career.